All right, this We the People News. One more time at it. All right, educational purposes only. Okay, not attorney, not giving legal advice. I do, however, sometimes bring up my opinion. Okay, some of you guys already know me. Most of the time, because we don't never look straight forward. We always look around us, be able to protect ourselves by any means necessary. All right. I probably should have done this a little bit different because I jumped the gun. Let me see about him explaining something. All right. I guess we'll start there. Okay, so this is let's get this started. High frequency radio. Okay, the meaning of the statue's construction. Okay, now I bring it up a little closer because eventually it's going to change it around a little bit, so you won't see everything I would see. So there's your notice on that. But he's got more knowledge in his pinky than I do in my whole entire body, and all my offspring's body, and my wife's body. All right, I'm an idiot compared to him on knowledge. All right, so just give you head knowledge. Go check him out. His videos are long, and he'll tell you what the wink wink sovereign citizens are doing wrong in court. So he does do some videos about it and sit there and actually tear it apart and explain what they did right and wrong. All right, let's go.
All right, so this is the abatement right here after it's converted into a word format. Now, the abatement process in this Don Quixote document is an administrative process. He has given you an entire administrative process from beginning to end. He gave you the entire process. And that's why I like it so much, is because it's thorough in that kind of way. I'm always talking about the administrative process. I don't know if people realize it or not, but I'm always giving you examples of completed administrative processes. They're out there for you to see from beginning to end what it's supposed to look like. 4 different scenarios, too. This scenario, because all administrative processes don't operate exactly the same way. If you're doing an administrative process on something public, say like the Fair Debt Collection Practices Act, it's going to have some different time frames involved because it's 21 days that they have to answer as opposed to 10. But you can do an administrative process in the public or the private. That's all it is. It's just a evidence gathering tool. Everybody kind of uses one. What it is for, it is to have evidence, which means you have witnesses, because evidence is really like witnesses. That's what they really kind of like are synonymous to. And you need 2 of them. You need 2 witnesses. That comes out of the Bible. So when you do an administrative process, you are evidence gathering. You're getting witnesses. And the witnesses are the post office, the 3811 form. That is a witness to the fact that you mailed something to someone. And then the affidavit of mailing from the notary is a witness of what exactly was in the envelope, that they did and receive the notice. And if they had a duty to respond, then there are some remedies available for that when they don't in equity. All right. So let's look at, let me see if I can make my picture.
Now, being safe than sorry, should you rebut any notices that comes through regular mail? Yes, unless you are fully aware of what he just said. Okay, but moreover, it can be converted into if it's got money due owed or anything like that, mail fraud. Okay, so and government has a tendency to send you regular mail. Well, that's mail fraud. Uh, but that goes into a deeper category, y'all.
Try to get out of the way. right. Okay, so let's look at this. All right, so the first thing I'm going to do, we're going to go down here and we're going to read after you get past the introduction and him talking about it. You're going to see some letters, and the first letter, one of the first letters he has is to a judge. This is one I got for the judge. That's a notice to abate. All right. So I'm going to show you how I'm going to do this. So this notice to the judge is this is a good letter too. I have to read this. I have to read this to you. We have to actually read this because I always read this to anybody I'm in front of because this is one of the best letters that I've ever read to a judge about informing a judge of what your status is. All right, of informing a judge what your status is, and it is based off of a keen understanding of the fact that this is a legislative venue. It also demonstrates that you understand separation of powers, okay, because they are not Article 3 courts. And it also helps them understand that you understand that the only way that they could bring you into that venue is that you would have to have a presumed status of a U.S. citizen. You would have to have been presumed to relinquish your status in the constitutional republic. All right, so he's addressing all that. This is what's called rebutting the presumptions, and it's done in a very intelligent way. You're not going to sound like a fucking, sovereign citizen. But anyway, it goes to the Honorable Judge so and so. When I specially visit your court on a forced response on such and such date to a bill of pains and penalties issued by so and so officer, employed by the so and so police agency, employed by the corporate Georgia state. I move.
Now, to give fair notice, remember in your Constitution, state and federal, bill of attainder is ex post facto. All right. In a constitutional republic and constitution. Okay. So, just saying, every state has it.
Court and you, Judge so and so, to take judicial notice that my special visitation was forced, that my visitation is special and not general, since this notice is my timely and specific objection to the presumptions upon which a false conclusion of law has been made administratively with regard to my status before this court. Now, you see, he has a lot of key things in here. He brings up the fact that it is a presumption. He lets them know that he's making a special appearance by saying it's a special visitation and it's not a general appearance. A bill of pains and penalties as a forced response. When you're forced to come in, the reason that this is called an abatement is because there is a error on the part of the state by presuming that you're an artificial person when real living souls should be brought before an Article 3 court. This is the argument that, in case you're watching, that people in the Patriot community are making. We're arguing the fact that the jurisdiction that your courts operate under are administrative courts that only have the jurisdiction to entertain corporate matters. Okay, to entertain, and that you have assigned everyone a corporate entity, and that is what you are engaging, which is why you write the name in all capital letters. You try to, try to get away from that fact as if people are stupid, but, it's obvious that you're writing the name in all capital letters for a reason. It's for a reason it's on the driver's license in all capital letters. There's a reason it's on all your utility bills in all capital letters. There's a reason on your checks issued by the banker in all capital letters. It's a reason when the senators convene in Congress and they're having a discussion, their name is in all capital letters. It's a reason when you go before a judge and you see his nameplate, it's in all capital letters. There's a reason for all of this. You can't tell us there's no reason. And also, this is not within the convention of what is accepted as correct grammar. So there are no rules of grammar that allow for you to write things in all capital letters. And you are educated and intelligent people. I know you're not trying to do what they do on the internet with ebonics and things like that. So there has to be a reason to it. So that first paragraph in this is addressing some very, very nice things. The second paragraph says the plaintiff in this case is an administrative officer representing the corporate and de facto state of Georgia, which has legislative power to compel performance upon the letter of its statutes upon all persons subject to its jurisdiction. The only due process that its legislative courts recognize is the right to be heard on the facts of the case. Now, you see right here, we're also bringing up legislative courts, all right? And we're also telling what their jurisdiction is to compel performance on, there's a presumption, okay?
So education purposes only, right? Administrative is legislative, okay? Came from their legislatures. Article 3, judicial, judges, real judges, not magistrates, right, is where your rights are. And, you're not operating in some form of business, commerce, trust, all that kind of stuff, right? So this is the reason why I say even when there's a criminal courts, it's still administrative, especially when they add some type of bill to it, an attachment, right? It's under administrative. And judges are not supposed to be administrative and judicial, Article 3. It's supposed to be one or the other. But they mixed it because they come up with the rules instead of your legislatures.
Plaintiff in this case is an administrative officer representing the corporate and de facto corporate, state of Georgia, which has legislative power to compel. We understand we're dealing with a legislative branch of government. We understand we're dealing with a legislative court. Okay, this is what we are saying. We understand there are different courts, that the Constitution delegates power to a legislative branch of government, state and federal. On the federal level, it's Article 1, Section 8, Clause 9. Congress has the ability to institute tribunals that are inferior to the Supreme Court. Now, these two courts, one is under Article 1, and one is under Article 3. They both can't be having the same powers if there is such thing as separation.
Yeah, Article 1 is the administrative courts, magistrates. Article 3 is the judicial. All right, Article 3 is what that would be.
Powers. So what is the distinction between the two? Seems like that would be the intelligent thing to ask, unless that you think that we're supposed to believe that they both have the same power, which would mean you'd be a bumbling idiot with all the court case law on the record that we can go to and find out that that's not the case. So, so that's what we're trying to come to a conclusion. What kind of court is it that we're dealing with? Is this a legislative court, or is this what we call an Article 3 court or a constitutional court? Article 3 courts are defenders of private rights. Article 3 courts are the protectors, or they're the gateway. They block the government, Article 1 and Article 2 branches, from encroaching on private rights. See, when you read the Constitution is not, a Constitution don't really have anything to do with you. It has something to do with the government. It forms government and it restrains government, just like any trust document. It allegates.
And this is what I've been saying. It does not apply to you. But since you've gone ahead and accept your corporation body in their corporate United States corporation, or the state of Texas, right? You think you have rights, and you go, I got rights. No, you don't. You signed, apparently you intervened in a contract, okay? Unknowingly. And this is where we've had issues today, because nobody's taught us these things at all until when internet really became popularized.
Powers to the trustees, and they can't act beyond that scope. That's called ultra-virus. Ultra-virus is when they act beyond the scope of their authority, all right, which is the Constitution. Now, They're not acting beyond
And that's called outside the four corners.
the scope of their authority. What they have done is they have inveigled, which means deceived, okay, their constituency into buying into another status that is based off of a Marxist, communist, socialist type scheme that was orchestrated in 1933 under the Franklin Delano Roosevelt administration called the New Deal program, which gave us what is called welfare today. So this is the things that we're looking at anytime we come into the courtroom, whether it's a traffic ticket or you're fighting for your house or for your freedom. That's always the underlying issue. What kind of court are we being brought into? Okay, how is this being adjudicated? Is there a certain, and what it is you have a stat. They're treating you like you're a child because you're not being brought in a court for adults. You're being brought in a court for dependents. Y'all are our dependents. And that's how we're exercising authority over you. Because you have demonstrated time and time again that you can't govern yourself. And you have the nerve, the audacity, the unmitigated gall to sit there and try to call yourself sovereign. This is what these people are thinking. This is how these people think. You are sovereign. You can't even govern yourself. The only way...
Same thing. You have the gall enough to call yourself a man. You have a gall enough to call yourself a woman. No, you can't even take care of your own self.
The only reason we have government is because you refuse to govern yourself and follow the laws of the Creator. And we are demonstrating it every day. Look at us. Look what we got doing. We got y'all having babies out of wedlock, children, fatherless homes, all kind of things that are going on. You know, they're looking at us as heathens. Okay? Heathens. And you got to understand that there is an underlying spiritual tone to all of this because all of this is derived. We're talking about equity. In the Bible, God says, I judge my people with equity.
All right. Well, anyway, I wanted to kind of just go ahead and leave that there, but give you a little touch of knowledge. And again, if you want to check out the whole thing, or, you know, if you want me to make another copy of this, you know, this is a high frequency radio, okay? The meaning of statues, consideration, okay? The same. Think outside the box, just so we the people news. Bye, y'all. Know where you're standing. Okay, the good book says, my people will perish due to lack of knowledge. Well, we become bums to the state. Till next time. Bye, y'all.